So what we have now is something that we really wanted to do. When we discussed the plan for this year conference, this was one of the first ideas that we had. So you may have seen on social media that we asked for your questions. We will try our best to answer your questions in the space. But first, I will introduce all of the great speakers that we have here, although you may know a few of them already. But first, we have decided that we will actually go around the table and try our best to give you a sense of the subjects and the topics that we think you can research, whether you are a master's student, a PhD, or a professor in computer science or antitrust. So we have just half an hour. We're going to try our best to make it very dynamic because it's quite late here in Europe. And so without further ado, let me start introducing. So you know Alex, who moderated a panel already earlier today. You know Theodora, you know Thayani as well. So let me introduce in the order of my screen, Bjorn, who is a associate in a law firm in Luxembourg called Arendt. Bjorn is a graduate in computational law and is also studying computer science in London. So he's going to be one of those rare computational lawyers with proper computer science expertise. Alexandra, hi, nice to meet you. Nice to see you. Not the first time we met. Bjorn, full disclosure, was one of my students. So it's good to see you. Alexandra is a Sciences Po graduate. She's now at the College of Europe. So we've been also talking quite a lot about computational antitrust, the technique, but also, you know, what it takes from a more political point of view to implement those tools within the agencies. So it's good to have you here with us. And Carol, who is a legal expert here in the Netherlands, in Amsterdam, in a law firm called Loyens, and he's also writing a PhD on the subject of antitrust and blockchain. So it's also good to see you here. So again, the plan is for now for me to go around the table and ask every single one of you if you can suggest one or two or three subjects that you think are feasible and important in the field of computational antitrust. I will start in the order of the list that I've created. So Carol, you are the very first to go.
Thank you very much, Thibault. Thank you for the very nice introduction. So as you already mentioned, so as I'm doing the research in blockchain antitrust, the topic which I would like to propose for everyone to look into, at least for those who find it relevant and interesting, is the implementation of computational antitrust in the ex-ante regulation of in blockchain communities, so that these networks are compliant with competition law, specifically with the laws prohibiting the cartels, and also which would at the same time facilitate for the competition authorities to do those screenings of those blockchain networks.
All right, thanks very much. What I forgot to mention is that please feel free to ask further questions in the Q&A. If you want us to deepen the subject, we are very happy to do so. If you have also substantial questions, we will try our best to devote 10 minutes to answer your questions. But Carol, thank you very much. Alexandra, I think you're next.
Thank you, Thibault, for the introduction and for having me here. So my topic is more a little bit legal, and I wanted to build up on the panel on the algorithmic governance, where the principle of due process was discussed, and also on the panel, today panel about merger simulations models, where we discussed the burden of proof with regards to computational evidence. And so I wanted to grapple with the issue of procedural aspect of computational antitrust. We have seen in the EU Qualcomm exclusive payment judgment the significance of procedural breaches and their impact on the rights of defense and hence the outcome of the case. With the implementation and development of computational antitrust techniques by antitrust agencies, we also have to start thinking about how to make sure that those are not later quashed by the courts if you want to make a computational antitrust successful. And such risk already occurred in the Eriks Loomis case, a criminal case though, but which was mentioned yesterday where recidivism risk assessment tool was used and where the defense argued that they were not provided with the document that contained this risk assessment. Procedural rights will be likely invoked and relied upon by companies during the proceedings in order to undermine the computational effort undertaken by agencies. And according to the principle to a fair hearing, the Commission must give the undertaking concerned the opportunity to examine all the documents in the investigations file that may be relevant for its defense, which I assume could potentially include algorithms which were used for the analysis. And as we know from the previous panel, the agencies are reluctant to share them with private sector. However, the more importance we attach to the results provided by the computational antitrust tools, the more likely they will be challenged by the defendant. So I think one could act preemptively, and I think we could think about designing procedural best practice rules or guidelines governing the use of computational tools in antitrust. And for example, we could determine in advance the evidentiary value of proofs acquired through different AA techniques.
All right, thanks a lot. We'll actually see you tomorrow as well to moderate a panel. Behind the scene, I can share what happened is that we all decided to share just a few sentences about what we wanted to discuss for this panel. And none of us had similar subjects, which I think shows the scope of our subject. Bjorn, you're next.
Thanks, Thibaut. Yes, what I would suggest for our students out here to research is algorithmic bias in computational antitrust. So you can look at the idea of what if an algorithm discriminates? What if an algorithm which is used by competition authorities and the competition authorities heavily relies on that algorithm, what if it decides to have an embedded behavior which causes bias and which leads certain investigations into certain directions, or causes certain interpretations which adversely affect certain people in the market? How would the market protect itself from such algorithmic bias? And you can also explore it from the market side, where you could look at at law firms potentially making use of computational tools to try and assess a merger, and what would happen if a law firm excessively relies on such tools, and how could they protect themselves from potential liability through the use of such computational antitrust tools. So yeah, that's an interesting subject you could explore, and there's various different facets to it, but I would strongly recommend looking into it.
Yeah, thanks a lot. I've seen a few PhD candidates now working on computational antitrust issues and challenges. I haven't seen much research in the space, and as Eleonore and Doug also discussed, right, the facts to use computational antitrust could already be or create biases and discrimination. So that's a very interesting one indeed. So Yanni, you're next.
Thank you very much, Thibaut. I think from what we have seen here today, especially from the last panel, is that digital screening development requires long-term investment to develop, maintain, and these tools and methods. And many scholars and even the own OECD advocate that the competition authorities can benefit from international cooperation. And I think this is an amazing research topic to explore. For instance, sharing data could be constrained by data sensitivity and by privacy issues, but there are solutions for that. I think one could try to research those topics. And also, I think that recently, the Danish Competition Authority developed its own screening tools and cooperated and shared them with the Spanish and Swedish competition authorities. So another subtopic could be how competition authorities could cooperate and try to design the best screening tools possible.
Yeah, thanks a lot. That is something that we discussed just a tiny bit today, that appears in a paper that we published, where they argued, or actually it was yesterday, where they argued that you could actually design machine learning in an agency and then send the data or maybe the algo to another agency. So very interesting one indeed. Alex, you're next.
Thank you. Good to see you all again. I will take my practitioner hat for this question, because I think computational antitrust can also be very helpful in terms of compliance and compliance assessment in general, because this kind of tools can be used to analyze legal documents, to label them, and to maybe identify possible risks, which can work both for private sector but also for competition agencies at the same time. Identify maybe areas of risk or key people or key stakeholders, and understanding their importance in the whole structure of a company or of a sector. Maybe I'm thinking here maybe using network analysis for this kind of things. And finally, I think that computational antitrust can also be used in monitoring and implementing remedies. If we're talking about merger or other situations in which remedies are imposed, it might be relevant, especially in the age of algorithms, right, to have real-time monitoring of maybe very specific types of remedies.
Thanks a lot. That makes me think about what we just heard on the previous panel, right? The use of new technique to try to analyze risky words within PDF and extract that and deepen the analysis that way. It's, I think, very interesting as well. Theodora, the floor is yours.
So you've heard a lot from me today already, so I'll just keep it short and sweet. But because I'm a classical PhD student, I just sell to you my research agenda. So two things I'm interested in are, first, the future of the firm. And by this, I mean the fact that the organization of economic activity is moving towards less centralized and more collaborative forms of production. We see how firms are increasingly embedded in these contractual networks for innovation. We also see the emergence of DAOs. And the question is, how should antitrust rethink its framework and accommodate these new forms of production, which are more collaborative and less centralized? And the second thing I'm working on are data markets. And the antitrust angle here is that we tend to see information sharing as being anti-competitive and risky, but we have to face the reality that data is the lifeblood of the new economy. So we can envisage perhaps computational tools which could monitor data exchanges and ensure that only pro-competitive data gets shared, which enhances access to innovation and ends up being consumer welfare friendly.
All right, I'm not on mute. No, thanks a lot. I see reactions in the chat. Maria is saying to Alexandra that it's a fascinating topic and that she faced a similar issue as a case handler. Again, I think we gather experience here in practice and academic. So I hope that we can cover pretty much a big chunk of the field. Let me share my thoughts. I have not one, not two, not three, but four suggestions. I'll be quick. The first one, and it wouldn't be a surprise if you were here with us earlier today, you could definitely expand the API that I've presented. in your own jurisdictions, and even at the EU level, you could do it for Article 101, merger control, as I mentioned. So that's the first. If you are interested in that, try to transpose competition law into decision trees. If you are more skilled, you could run the analysis so that you will extract the principles of antitrust. But again, if not, create those trees, transpose that into APIs, and try to deploy that and see if it works and which challenges you are facing. That's the very first. The second one is, and it will be maybe a surprise to Alex, but I think that network analysis is very important. And the reason why it might be a surprise is that I'm not aware of any analysis of the FTC or DOJ, or in fact, all the jurisdictions outside of Europe, where you will take the decisions, label the decisions, which means that you identify variables such as the name of the companies, the fine, the type of practice, put that into an Excel document, and then using many open source software such as GIF5, that's just one of those, try to visualize the data and see if you can derive something from it. It's something that, again, does not require computer science expertise, and I'm surprised that it does not exist, and it could be easily done. I mean, easily. It's doable. The third, you can identify the use of computational antitrust within the existing case law. We are trying to do that in our publications. You will find indeed mentions of where agencies are using computational antitrust, but I haven't seen yet a study that will gather pretty much all there is to know. Now, it's impossible to read all the decisions ever published, but you could do it per jurisdictions or per practice, right? So you tackle one type of practice. We've heard a lot today about big rigging. It might be one where you will try to scrape all there is to scrape in those decisions. The fourth is the use of agent-based modeling. This one is more advanced. And I hope we can publish research in the space in 2023. But there is room for lots of interesting papers. Let me just show you what you can achieve with agent-based modeling. The idea is that you create a computer simulation, you change the variables in the environments, and see how agent will react. If I take just a minute, let's imagine that the little yellow dot represents agents, you and me, and that we want to see how they react to new regulations or new competitors in the search engine market. What you see on the top left corner is just one competitor, just let's say Google. If you are sensible to privacy, you will see on the right that some agent will decide not to use Google, but you don't have many options. What you see though, and that's the one that appears, let me show you just over here, is that there is just one search engine, so Google, but GDPR. So suddenly more agents are willing to use it. So introducing GDPR changes the behaviors of the agents. And here on the right, you see that there are two actually. One that is more privacy friendly, and therefore you may see how introducing a new competitor changes how the dot will behave. This will be extremely interesting to try to run this type of analysis and get rid of the idea of the average consumer, right? And to do something more granular. If you are interested in that, there is, again, an open source software called NetLogo. If you spend 2, 3, 4 days on it, you will create your first simulations. There are lots of tutorials that you could use on YouTube. So those are the 4 that I wanted to mention. Now we have questions we need to answer. But again, I see that quite a few of you are with us right now. So feel free to just ask research questions that you would like us to answer, or if you want us to deepen what we just explained. But for now, we will answer the question that we received. And I will actually give the floor back to Theodora for a first question that we will try to answer.
So should I also read out the question? I guess so, since you didn't ask it yourself. So EU moved from a system of centralized notification and authorization to a decentralized system where the treaty's provisions on competition law are directly applicable. However, it seems that such system results in a lower detection of anti-competitive agreements and abuse of dominant position. Since computational antitrust holds a promise of more automatized enforcement of competition law, would it be desirable to introduce a system where companies are obliged to submit their agreements to competition authorities, which are then analyzed through AI and ML tools to help the authorities to detect anti-competitive behavior? Okay, so that's a tough one. As I said in the previous panel, I think that in a distant future, it would be possible to imagine a sort of do-it-yourself antitrust, where firms can self-screen their agreements through computational tools. But before we get there, I think that we have to be very mindful of Thibaut's favorite word, which is trade-offs. And by that, I mean that we have to ask ourselves whether we want to maximize detection rates at the expense of the quality of the assessment, or whether we are okay with having some agreements fall through the cracks, but making sure that those that are detected are actually properly assessed. And I think that the ambition at this stage is not so much to move back to centralized notification and having everything pass through the agencies, but more so to give agencies first the data and then the tools they need to process the data when making decisions. That's my take on this.
All right, thanks a lot. To all of you on the panel right now, if you want to add anything, feel free to just jump in. There is a great question that just dropped in the chat. So while I will answer two questions that we received, you could have a look at this and see if you are inspired. One question in the Q&A, the person's asking me if I can provide the source of those images, I suppose, those ones. I just created that for the sake of this panel. So this is not, I should have mentioned that, I wanted to. This is not the result of a proper simulation. This is just to show you that simulating what may happen on the market might be helpful. But again, this is just a simulation. It will never mimic what will happen in the real space. So there are limitations we need to discuss. And yet I think this is an important and an interesting subject. One question we received, and I will read it out loud, asked if there are any already closed competition cases whose outcome would have been different if computational antitrust tools were implemented, which ones and why. So it's hard to answer because, of course, we will never have the counterfactual, right? So we will never know if in one of the Google cases or the Amazon case or cases before the FTC or any other jurisdictions, the outcome would have been different. I think the answer is positive, but it's hard to say because no counterfactual, and also because the agencies won't always disclose when they use computational tools. And I know that from discussions behind the doors, where sometimes it's not really obvious that the agency used computational tools. Why? Because saying so may put the agency in a difficult position before the judges, right, in appeal. So sorry, but it's hard to answer this one. Although something we've heard today with Oliver and Victoria is that an idea will also be to take, let's say, merger decisions where the agency relied on simulations and see if indeed the simulations were eventually came closer to reality or if they were totally off the grid, right? So I think this might be an easy way to answer your question and a good research subject. Another one, and I will finish there. I was asked which kind of tools can help agencies to measure anti or pro-competitiveness of a given behavior, and which kind of variables we need to take into account. To answer this one, and that is something we discussed yesterday, if you want to deploy computational tools, you want first to know the reason why you want to deploy the tool, right? And it will give you the right tool you need to deploy. First, which standards do we want to pursue? Is it the consumer welfare standards? Do we want something broader? If you can't answer this question, you can't analyze the pro or anti-competitiveness of a practice. Once you know the standard, you want to answer or to know which legality test you have to follow, right? Once you answer the standard and the legality tests, there are different tools that you need to combine. Let me give you an example. If we talk about a practice that is a restriction by object or a per se violation of antitrust in the US, you can certainly think about NLP, natural language processing, right? Where certain keywords will indicate that indeed the practice has been implemented, and you can stop the analysis there. If on the contrary, you go for a practice or you pursue a practice that is a restriction by effect or that should be studied under the rule of reason, then it depends on the practice. If it's a pricing strategy, then you can potentially, and we've published paper in the space, use machine learning to try to better understand if practice match certain behaviors. But if you want to see what is, or to measure a practice that is related to the quality of a product, maybe you want to go for agent-based modeling that I just presented to you and see how agents behave, right, and react. Finally, a last point that I want to mention is the one for the remedies. You can have a look at prediction markets. If you are not familiar with the concept, you will find a lot if you just Google that or chat GDP3, the concept. The idea is that you force participants to put money where their mouth is. So you may say, okay, if we allow the merger, do you think the prices will go up and down or down? People will vote, will bet, put money on it. And if they are wrong, they will lose the money. So that might be a way to gather information on the market and decide accordingly. So this is all I wanted to tell you. Now, I see there are 2 questions in the chat. I will read it out loud and see if anyone wants to answer this one. We are asked if there is an interest in NLP, natural language processing, where should one start to get familiar with the concepts, get familiar with the techniques, especially when it comes to text classification? I don't want to put you on the spot, but I think, Alex, you can certainly answer the question. But if any others want to give it a try, feel free.
I have one recommendation, which I think it's very useful in general in terms of computational studies. There's a very interesting summer school. It's called the Summer Institute in Computational Social Sciences. I can leave you the link. It has basically 2 weeks of presentations and discussions and workshops on this kind of methods. And also there's a very substantial library of resources where you can find a lot of, let's say, introductory materials for people that are interested in this kind of tools. I can leave the link also in the chat for this.
Thanks a lot. I actually thought you will mention the NLLP conference. That's also a good one.
Also,
you want
yeah,
to check it out.
That's a good one, yeah.
So just Google NLLP. And you get to regular workshop where you could definitely familiar yourself with NLP and then try to apply that to antitrust or privacy, IP, anything you may want to apply to. Any other participants would like to answer this one, or should we move ahead? All right, we have 3 more minutes. There is another question in the chats, and I think this one is for you, Bjorn. I will read it out loud. So you indeed indicated that researching algorithmic biases might be a good path. And the question relates to the substantial part of it. We are asked, or you are asked, if computational antitrust is different than other fields of the law, where usually the discrimination comes from the data set that is used to train the algo. And the question is whether or not this would be different for computational antitrust. So whether or not discrimination may come from the tool itself and not the data training the tool.
That's a very good question. I think that, like for other fields of law, it really depends on the algorithm used. So the more complex the algorithm gets, the more you'll have a higher chance of there being some form of bias, which doesn't necessarily stem from the data itself. You can imagine that the more computational antitrust, but also other fields of law starts making use of artificial intelligence, and we have this black box problem where we do not necessarily know whether the bias comes from the algorithm itself or from the data that it is fed into, that is fed to the algorithm for it to function. So I don't think at this stage there is much difference fundamentally in bias between computational antitrust and other fields of law. But I think there's a potential bias which may develop in the future the more complex tools are being used.
All right, thanks a lot. You also used one of my other favorite words, the one of complex and complexity. A topic for a different day. Actually, tomorrow we'll be discussing complexity theory. I want to finish on time, but before that, I will ask all of you if you want to add anything. But let me tell all of you here in the chat right now, but also if you watch this video later on YouTube, because this one we know we get the consent from all the speakers to publish it. If you are interested in those subjects and feel that we can help, feel free to reach out to one of us, right? Especially the person who recommended that you study one field of research. We're always happy to help you and answer your emails. So feel free to go on our website, computationalantitrust.com, find our email addresses and send an email.